Hello everyone, welcome in. We're going to be discussing the motion hearing from yesterday. Sorry if I'm a bit late to the party, but after the judge asked for the attorneys to present findings of facts in 2 weeks, I went digging to find some facts to share with all of you in regards to the issues at hand right now. I've seen many people upset over the fact that Alexee is able to attend college. I will say that the judge did have good reason for removing the condition of Alexee's bond because it was filed under a domestic violence rule, and that just doesn't really apply to this situation. You will notice that Gary did make sure to say that Alexee and Devin will not be discussing the case and that he has gotten Alexee medical care to ensure she will not get pregnant. I mean, that's great in theory, but unless her tubes are tied or she's had a hysterectomy or whatever, you can always still get pregnant. We will leave that issue where it is because until further notice, that is a moot point. First, I would like to touch on how great the prosecutor did in this hearing. Very clear, very succinct, made note that both sides see this case differently, which I feel is like a very good point because the judge is soon going to be able to see who may or may not have been embellishing the facts. Now that the judge will be presented with all of the information, mind you that the timeline provided right now to the judge came from Gary Mitchell. I hope the state is able to provide a timeline as well because there could be obvious bias in Gary's information or how he presents it, just my opinion. But that's one of the first things we kind of do in cases like this. In cases like this, I made two separate timelines, one for the hospital and one for the police. On the night in question, they're here on the channel if anyone wants to reference them. I wove by time the actions of both police officers into one timeline through both of their body cams. It was honestly a very time-consuming process. I think it probably took at least 4 hours, even with the videos on 2 times speed. So I know that it will be quite the task for the state to create an official timeline. But again, it's necessary so we don't use the defense's timeline. I would like to touch on essentially how Gary talked about the charge nurse moving the baby. I do have a video of that here for us. I have been saying that Gary will not mention the bag. He's not going to talk about the bag. He's distancing himself from the bag and the trash can. So real quick, I will put it here, a little clip of how he addressed this issue.
That came from an interview later on when the police are interviewing the various nursing staff. That's a charge nurse that you're talking about, that you were talking to. He also was the one that took the baby from the bathroom into an examining room and called the doctor to come.
So with his ability to sidestep the facts, he should take up line dancing or something. His evasion is going to be matched by the state reinforcing the fact that the baby was found in a bag multiple times. He's never going to refer to the baby being in a bag, and if he does, it will only be to show that the hospital left the baby in a bag. That's just my opinion, but he's done a number of interviews and now a hearing, and as we just saw, he's able to sidestep the baby being in the bag time and time again. I think this is Gary's last stand when it comes to things going in his favor. Things have been going in their favor so far, but I do believe stuff is about to take a turn. Again, that's just my opinion. So let's get into the first issue. It's not a real big issue. They kind of already decided it. It was venue. We got some solids in the case. They will be in Eddy County. They're going to do a supplemental jury questionnaire. They're going to pool a large number of jurors. And the judge did say, obviously, hearing about the case is not enough to disqualify you. So that gives us a little bit of basis as to what we're doing when it's coming to jury selection. We did predict that here. We kind of figured that's exactly how it would be. Again, the Lori Vallow Daybell trial did pool 1,800 people, so we'll see if this case gets anywhere near that. Issue 2 is privilege, which is seemingly one of the biggest issues that everyone's arguing about in this case, right? So it sounded as though the judge is likely to let in the hallway video. It is a public corridor. She didn't seem to have issue with that. So let's bet right now on the hallway video being allowed in. The rest of the evidence is in question still. It's going to be reviewed by the judge. I've seen people be extremely happy that Rosa may or may not be considered a third party. They hope that she is, and that just by Rosa's mere presence that she negates privilege. That would just be some great icing on the cake. We don't know if that'll happen, but I have seen people seem to be pretty excited about that. When it comes to the hallway video, I am hoping that video Also opens the door to the statement that Alexee made when she exited the bathroom, which was, "I'm on my period," which was her trying to essentially throw everyone off from why there might be a bunch of blood on the floor, right? And I think that also really would help solidify for the jury her intent in making sure that that baby was never found. And that's just my opinion. They need to parse out what is video evidence, what is statement evidence, right? What is record evidence. So I'm hoping that the video of her being in the hallway also leads the door to the statement she made when she came out of the bathroom on that video admissible. We'll see about that. But I do think that's a pretty important statement as far as Alexee's intent. I put this on here because I didn't want to make a whole Miranda part here, but I'm going to address Miranda in a little bit down the road here in a second. But the judge did make a face when she was told that Alexee was in custody and not Mirandized. Now, that doesn't mean we're completely SOL here on this. Like, I'll explain down the road a little bit more about that. But I will say, she did make a face, like a disgruntled, like she did not enjoy that fact. So, that being said, a quick note about Rosa possibly being a third party, considered a third party in negating the privilege here. Everyone I see is hopeful for that irony, and it is a great argument by the state. Gary also makes an okay argument as well about people always being in people's hospital rooms. Now, most case law regarding third party presence is in regards to attorney-client privilege, and most case law regarding third parties with HIPAA privilege is in regards to companies that medical entities of HIPAA, do business with, like billing companies or whatever, right? So it seems as though it will be up to the judge's discretion if she thinks Alexee waived privilege by allowing her mother's presence. So the attorneys are now tasked with finding case law and any other facts that they can to support their side in these motions, right? The findings of facts asked for by the judge. When you attempt to look for cases with issues that we're facing in this case, you find mostly civil cases, right? Medical information and civil cases, they go hand in hand. But when it comes to HIPAA privilege in a criminal case, there's less case law to reference. When you see criminal acts on hospital grounds, it seems it's commonly patient on doctor crime, right? Or a visitor is attacking a patient. It's not so common to find a homicide taking place on hospital property where it is a patient who commits the homicide and they weave in and out of HIPAA throughout the whole act of the crime, right? That is definitely pretty rare. It's because of this that I say the judge in this case will be setting precedent, honestly. HIPAA and New Mexico Rule 11504 already take into account the investigation by police into a crime on hospital property, of course, but that is typically in a different scenario, right? It's not typically that the patient went and murdered their baby in the bathroom, allegedly, and so that's why this is kind of a precedent-setting case here. With that being said, I have found a few things. First off, this is Santa Fe, which is the capital of New Mexico. This is their body cam and public records statute. So, every person has a right to inspect public records of the state except public records, meaning body cam footage, records pertaining to physical or mental examinations, and medical treatment of persons confined to an institution. I highlighted of persons confined to an institution because Alexee was not confined to an institution, so all records pertaining to physical or mental examinations and medical treatment should be public record, which also means it should be admissible. That's just my opinion. Moving on, I also found Connecticut seems to be like a leading, they're ahead of others when it comes to legislating body cam footage and medical actions caught on video and things like that. I believe if the judge looks to Connecticut, the conclusion she will find is there is no place for privilege in any of this evidence. Police were conducting their investigation. A crime took place. The statements made to doctors by Alexee were in furtherance of her crime. They should be admissible, including statements about being a virgin and denying pregnancy. Those statements are relevant and not regarding treatment, nor are part of a psychological evaluation. Therefore, statements offered by a suspect of a crime to medical staff in furtherance of their crime should not be considered privileged, especially when they are already subject to public records due to a police investigation. These statements should be considered relevant to the finder of fact as Alexee's motivation that night. right? Okay, so we can move on from this one to an actual New Mexico case that I found. So case law, here we go. Now we're finally getting into some case law. If you see, I made big and highlighted to show malice, knowledge, and preparation, purpose, or intent. Then I also made big and highlighted to corroborate a witness or admissions of the defendant. That's going to become important later. I think that this finding is quite compelling as to why the statements made to hospital staff should not be considered privileged and are relevant. This gets into a bit of argument, but the facts also show that Alexee was not honest post-birth. We can have reason to believe she was not honest pre-birth. Had these witnesses been told the same statements and were not entities of HIPAA, all statements would be admissible and show Alexee's malice, knowledge, and preparation, purpose, and intent. HIPAA specifically states the patient must be seeking an accurate diagnosis and treatment. I believe that wording is especially significant here, as according to witness statements, Alexee did not seek accurate diagnosis, rather attempted to avoid the truth of the diagnosis when presented the opportunity. Had these intentional statements been made to any other witnesses, they would be corroborated as admissions of the defendant. This also applies to any statements made by the defendant without a proper question being posed. Rather, voluntary statements made to explain her criminal actions, in which she admits to one of the charges in its entirety, that she put a baby in the bag because it was not crime. Right? We can move on from State versus Gray to this. This is not case law, but it is a note from the Attorney General from 1964 for New Mexico, and essentially I highlighted here any declarations by him. Again, remember this is 1964, so that says him all throughout this, but any declarations made by the defendant are pertinent, right? And admissible evidence. This is just a little bit of extra salt on the top, so to speak. It solidifies the point that admissions made by a defendant should always be admissible, but for malice disregard of the constitutional rights of the defendant. And that's just my opinion. I'm just kidding. So that's my last little bit of evidence in this, but I know I'm just a paralegal, but if I was the prosecutor on the case, I would maybe say a little something like this. The issue of privilege is integral to the law and the rights of all those who stand trial. Rule 11504 implies that the upholding of the privilege should be done in accordance to the privilege's intent, which is to protect citizens seeking health care without fear of publication. I offer that finding the statements made to hospital staff by the defendant admissible does not undermine the privilege that HIPAA and Rule 11504 seek to protect. Furthermore, qualifiers for the exception have been met. All statements made on body cam footage with the doctor present should be admissible by the exceptions to Rule 11504 because a suspected crime took place. The statements are not subject to Miranda, as defendant was not interrogated by police nor the doctor, but was under the equivalent of a probable cause investigation in which you are not free to go, but also not subject to Miranda. Defendant has asserted her Miranda rights 3 separate times in this case and has never made a statement to the police. Therefore, defendant's statements made voluntarily on body cam should be considered admissible. Statements made to witnesses considered entities of HIPAA that show defendant's malice, knowledge, and preparation, purpose, and intent should be considered admissible as they are evidence tending to show circumstances leading to the arrest of the defendant, her acts and conduct, her physical and mental condition. Therefore, any declaration by her are pertinent. Furthermore, the defense's alibi that her attorney has provided to Court TV but has not filed formally in regards to this case relies on the premise that the hospital staff caused this death. It would be unduly burdensome and reckless to exclude the statements made to the hospital staff as evidence when that is the only defense that has been offered by opposing counsel. Wherefore, we ask that all evidence in question not be suppressed and that the judge find this evidence relevant to the fact finder as to show defendant's furtherance of the crime, non-probative, non-privileged, and non-subject to Miranda, obtained by the court order and police investigation at scene of crime. Now, that's just my opinion, and again, I based it off a few different laws and rulings that I could find. Though there are similar cases and similar questions asked of courts before in regards to privilege and Miranda, how all of these issues are in one case leaves a lot of room for this decision to set some precedent. With that being said, both sides have 2 weeks to get their findings of fact to the judge, and I'm hopeful that shortly after that, we will have a decision from the judge. The defense has to come up with some really good arguments and some serious case law and hope that the judge is blind to the facts, in my opinion. It seems if there is an issue with Miranda, the police officers who were on the scene are willing and ready to testify, and that was great to see. I do not know which one of them it was, but one of the officers even spoke up when there was some hacking and tomfoolery or whatever going on, and he was like, hey, that guy just left the chat. And so you get a sense that the officers from that night are going to be strong witnesses, and they're able to explain why they did not Mirandize Alexee if we need them to. With that being said, if you're interested in following this case to trial, please subscribe, because I will be following it all along the way with a legal bent. If you have any comments, questions, or concerns, please feel free to leave them down below. I appreciate the conversation, and I try to get back to you as soon as possible. It's your girl Friday. I'll see you in the next video. Okay, bye!